Hello, my friends, and welcome to the night before Christmas. Thanks for coming to spend part of your Monday evening, April 15th, with me, 2024 for posterity. And let playoff hockey season begin. The New York Rangers, the New York Islanders, and the Boston Bruins are all going to the playoffs. Praise be. Not only are the Rangers going to the playoffs, but they won the President's Cup tonight because they are number one in the NHL with 55 wins, which is the most in franchise history. Are there any Rangers fans in the chat? Any Rangers fans? If you are a Rangers fan, give me an LGR in the chat. You know what that means. I know we have a lot of hockey fans here, so I scheduled this for 10:30 tonight because I knew all the games would be over by now, and they are. I told you I would root with you for the Bruins until playoff season, so sorry, but that's it. That's it. It's Rangers Town now, baby. But we can all agree on one thing, and that is that the Karen Reitz trial is starting tomorrow. Jury selection, anyway. So the only thing that we're going to see tomorrow is a 9:30 start. They're going to introduce the case. The judge will read initial jury instructions, and that's it. Cameras off for the rest of the process. And I don't know if they have said, I know I love you too, Paula. It's okay. It's okay. At least we can agree on some important things, right? But it feels like a good day today. I don't know. It just feels like a good day today. Yeah. What the puck? What the puck, Helena? I don't know. Helena Handbasket. Oh my God, that is amazing. That you're up for name of the night. First time I've ever seen that. Helena Handbasket. Welcome, welcome, welcome. Anybody new here? You have any new people here? Do I have any Rangers fans? I don't see any Rangers fans in the chat. Let's see. What about the motions, Mimi? They haven't been decided. Nothing has shown up in the court system. I'm assuming she's going to rule on them tomorrow or during trial. Maybe she will rule on them tomorrow. Some of them were just sort of like the motions in lemonade, as the closed captions called them. We'll decide as we go along, which really is the right way to do it. Decide them as the issues come up. So thank you, NDF, for your $10 super chat. 2 shows in one day with Melanie as a gift. Best stream regarding this case. Thank you. Thank you so very much. I did do an earlier live stream today because, as you know, I don't cover a ton of cases, because when I cover cases, it's because I feel really passionate about them. And I'm also right now covering the Oklahoma Panhandle case of the 2 Kansas moms who went missing and have now been confirmed to be not among the living. And apparently I must have said too many things earlier in that stream, which was at, I think, 5 o'clock Eastern, that immediately it was demonetized by YouTube as being unfriendly to advertisers. So who knows? You just can't report on the news anymore. But thank you, NDF, for coming back and hanging out with me again today, and for Susan for becoming a new member. So, what do you guys want to talk about tonight? This is like your show. This is like the night. 'Twas the night before Christmas, and all through the house, everyone's like a little kid at Christmas. They can't wait. Yeah, the poor children in that case, Kirsten. So sad. Thank you, Patronus, for telling everyone for welcoming everyone, for being an amazing moderator, and for telling everyone to hit the like button, because it helps the algorithm. YouTube has some weird algorithms, and who knows? If I could figure that out, I'd be like a bazillionaire probably by now. But they don't tell me. When are the feds coming? James wants to know. Maybe after Jeopardy attaches. That would be after jury selection, after the jury is seated. How long do I think jury selection will take? They haven't asked the attorneys. She has not asked the attorneys. It's not actually trial tomorrow. Tomorrow starts jury selection, just so nobody is confused. The trial will be fully televised. However, there will be one pool camera, one pool photographer. The media outlets are going to have to figure out amongst themselves who's allowed to stream what. And if they're going to, they're going to share it. Obviously, that's what they do. But Although she asked the attorneys how long the trial would take, and we're estimating the trial will take 7 weeks or so. She didn't ask the attorneys how long she thought jury selection would take. Tomorrow's Tuesday, so we're already a week short. She said they have we're already 1 day short. She said they have no jurors on Fridays. So I don't know if that means they don't bring new jurors in on Fridays or they don't bring any jurors in on Fridays and the jurors have Fridays off. So there may only be 3 days of jury selection this week. How long did it take to pick Chad Daybell's jury? I don't know. My guess is that the actual trial opening statements will not start until at the earliest a week from today, next Monday at the earliest. So your guess is as good as mine because she hasn't really talked about that. Yep. And a wake up. Wake up. Elf, thanks for being a member for 3 months. Let's go Mets and Karen Reed, of course. We're hockey. We're into hockey right now. Can't really get into baseball yet or really ever. When you start watching hockey and you become a hockey fan, I don't know, no offense to you baseball guys, people, women, men who like baseball, but I just find it really boring. It's like watching grass grow. There's no time limit. It just takes forever. I mean, I've heard they've instituted some time limits in baseball, but I don't know. Still not for me. Pierce says I heard no Friday at all. It is Massachusetts. I don't know. Court TV seems to favor the Commonwealth. No, I saw something interesting. Did you guys see Vinny's show from, I have a little tiny portion of it to play for you. He had a body language expert look at Karen's video statement from the precinct or from the headquarters that we watched last night. And I'm going to tell you what she said. Baseball means nap time. I love golf, but I find that if I put golf on, it can put me to sleep. Just the cadence of or something of the announcers puts me to sleep. And it's a good thing to take a nap. It's a good thing to take a nap too sometimes. Did you guys see the New York Post article today? I did a community post about it. Did anybody see it? Let's see. The New York Post is my favorite newspaper. It always has been because the articles are short. This was a very long article for the New York Post. And you can get your breaking news very quickly with the New York Post. And I thought this was a very fair article. Kirsten, if you haven't seen it, I made a community post about it with the link to the New York Post article, and I found it to be fair. What did you guys think? Tell me what you think. I was quoted in it. Sean McDonough was quoted in it. Aiden Carney was quoted in it. This is a Leech jersey. This is vintage, my friends. It's a Leech jersey. Yeah, so tell me what you think about that article. James said they did a good job. We're still talking about baseball. Scott McGinnis says no jury selection on Fridays usually, but Judge Cannoni may modify that for this trial. Once that trial is underway, the jury stays in trial on Fridays. I like to say on trial. A lot of other states say in trial, but I like to say on trial. But yeah, so she's going to do for the trial. It is going to be full days, Monday, Wednesday, Friday, and half day afternoons on Tuesday, Thursday. I'm going to plan to go gavel to gavel on the trial. I've been talking to Brandy and we may do some split streams because it's exhausting. I don't know. We have to see what happens after tomorrow. It's going to be interesting to see how far this trial will go. I'm not convinced that it's going to go all the way, but I've been wrong before. Thank you. Thank you, Kim. Kim says, I'm glad they interviewed you and not one of the other legal experts. Great article. Yeah, the comments. Go for the comments on the post. Lisa, are you here? I saw you commenting on the actual post in the post comments, and you were girl, you were keeping up with those comments. Tess says, Tess 617. I always read my horoscope every morning in the New York Post, so I saw the article right off. Yeah, I always read my horoscope for the New York Post as well. Kate says, I'm not convinced it's going to actually happen. I just can't imagine. Yes. It's crazy. BFeds, let's all say a prayer. We wake up with news of a bunch of arrests by the feds. I don't know. I just don't know what's going to happen. How would the trial end before the end? If there were other arrests made in the death of Boston police officer John O'Keefe, perhaps. I don't anticipate that happening, but I don't know. I feel like this is sort of like we're in an altered reality here, like an altered state. And, a lot of people, the Twidiots, took parts of my stream last night, posted them all over the cesspool of Twitter, calling me a liar. Like, okay. If reading from court documents and official investigative reports and watching hearings and analyzing them as a legal analyst makes me a liar, then I've been called a lot worse. So have at it, folks, because it's just gross over there. It's so vitriolic and personal. And come for me in the comments. I have merch that says it. Do it respectfully. Don't do it under an anonymous name in the cesspool of Twitter. Yeah, Twidiots. Exactly. Little cupcake. It's funny. It is, and it's like I can't even respond to them because all they want is attention. It's such a desperate plea for attention, isn't it? Yeah. Mm-hmm. There's trolls all over here. Which one? Tell me so we can get rid of them. Yeah, exactly, Pierre. Exactly. Exactly. All right, so let's do a little something. What I want to do is, yes, I heard that, Suzanne. Mr. O'Keefe has requested to sit on the Karen side of the courtroom. That is Officer John O'Keefe's dad. I heard that too. Lizica, that was you all over the New York Post comments today. I saw it. You were doing it. How very infuriating it must have been that you showed up in the New York Post today. Yeah, just something else to make those people go ballistic. I haven't even looked today. I don't really care. But look, if you can't show your face on a screen and you have a YouTube channel and you can't use your real name in the cesspool of Twitter because you're just spewing nonsense all day long, 8,000 tweets in a month, like, come on. It's ridiculous. Keeping it reals. Thanks for becoming a member. And boy, Ma times 2. Thanks for the $20. Las Vegas local. Thanks for the late live. I'm a stay-at-home mom, so I'm eating my ice cream with a quiet house watching you tonight. Go Vegas Nights. Between you and Emily Baker, I learned so much. Emily Baker also used to work with Alan Jackson. Oh, right. When she was a prosecutor, I guess, right? In LA. He was a prosecutor also. He prosecuted Phil Spector. Elf, thanks for the super chat. Is this normal to have jurors investigated? Never heard it before. Apparently it is something that happens in the wild land of Massachusetts. They're not really being investigated. They're running their criminal records. So that is an investigation. And is it to scare people away from jury duty? I don't know. This whole thing is crazy. The whole thing is crazy. So what I want to do, since many of you are new to this case, and even if you're not, you may not know because we did not go over together the documents that were unsealed by the judge. Remember, the Boston Globe came in and made a motion to unseal the original defense motion to toss the case based on information that they didn't think should have been introduced to the grand jury. And that motion was impounded or sealed, as we would call it in New York. And so we couldn't review that motion. And when we did go over that motion, the only part of it that we could review was the Commonwealth's response to that. And through that response, we learned a lot of stuff that happened in the original state grand jury before Karen Read was indicted in this case. And it was where the Aruba stuff came out, where the Higgins stuff came out, and some other things. But now that she has released the 135 pages, there's a lot more there that we didn't know about that was introduced to the grand jury. And there's a couple of things as I'm scrolling through the 135 pages, there's a lot of it that I highlighted. So a few things, I'm going to keep it to a few things. A lot of stuff about Sergeant Lank. who may have been a friendly. If you know, you know. A lot of stuff about the witnesses in Aruba and when they were interviewed, which I found very interesting. And this is a very complicated case, Kirsten. Jason Smith, I can't believe you're here. It's been so long. Hey, Melanie, I almost can't believe there's going to be a trial in this case. You're from Massachusetts, right? My fellow deadhead friend. You know? Yeah, it's what a long, strange trip it's been for this case. So, Lank bad. Andrew says Lank bad. Who cares about Aruba? Well, when I tell you when those witnesses were interviewed, it's going to blow your mind, Erica. It's going to blow your mind. Thanks, little cupcake, for telling people to hit the like button. All right, let's get into it because there's a lot of stuff here that you might not know. And also, tell me what you would like to talk about after we do this. And so here's the release of the docs. She released this stuff. We got to put it in the right view. She decided to release this stuff even after she was warned by the feds not to. This is Judge Cannoni, for those of you who are new here or have not been following this case. And she decided to release it. What's the date of this order? April 10th, with some redactions. She released it on April 10th. So we have the documents here. And what was unsealed is the original defendant's motion to dismiss the indictments, the original indictments of Karen Reed. And this was filed a long time ago. It was filed a long time ago. Hold on. Oops. Let me see when it was filed. I think all the way back in something like maybe let's just, we like to be accurate here because this is a fact-based channel that reads actual court documents and looks at actual police reports and investigative reports and watches actual court hearings. So let's get back to it. This is an easier way to do it. January 5th of 2023. So this was filed about a year ago. No, that can't be. This is wrong. Should say January 5th, 2024. Oops. The certificate of service. All right, so it's January 5th of 2024. Here it is right here. Here's the receipts. And as you may recall or may not recall, if you're just tuning into this case for the first time, the argument for this motion was that the indictments should be dismissed because, quote, the integrity of the grand jury proceeding was impaired by an unfair and misleading presentation to the jury, which requires dismissal of the indictments. Now, Judge Cannoni did deny this motion, but what I want to look at this motion, and that, it's a hard motion to win. I said that from the beginning. But the more I read started reading the arguments in this motion and putting everything together with the totality of everything that was presented to the grand jury, again, I'm scratching my head. Am I in the twilight zone? Like, this was so out there, the stuff that they presented to the grand jury. They called something like 8 witnesses to testify about the Aruba stuff. Well, I can't say 8 because, maybe if it's not 8, someone will call me a liar. So we'll wait until we get to that section. So we know what the facts are. We know what the charges are. If you're not familiar, go back. I've done, I don't know how many streams on this case so far, but probably well over 50 hours worth of coverage, analyzing all the documents that we can get our hands on, all the hearings, all the police reports. And over the course of 14 days for the state grand jury, the Commonwealth presented the testimony of 41 witnesses to the grand jury. They name them, many of them. And what I want to go to first is this. A majority of the witnesses who testified before the grand jury were not percipient witnesses to any of the events in question and were instead called for the purpose of testifying to remote and irrelevant, quote, bad character evidence and propensity evidence prejudicing the jury against Miss Reed, misleading the grand jury, confusing the issues, and wasting time. To be clear, not a single witness testified that they observed Ms. Reed strike O'Keefe with her vehicle, injure him in any way, or otherwise drive erratically on the night in question. I'll break from that for a second to give you your legal terminology of the day. What is a percipient witness? A percipient witness is a witness who actually sees, hears, or has admissible personal knowledge of the evidence about which he is testifying. That is a percipient witness, one with personal knowledge. And you're going to see here as we go through this that many of the officers read other officers' reports instead of having the actual officer who wrote the report come in and testify about what he actually saw, heard, people he spoke to. It's quite bizarre. But do you know what that prevents? Perjury charges. If you have somebody reading someone else's report into the record instead of testifying about what they actually saw and heard, because if they testify and they're not telling the truth in front of a grand jury, they can be brought up on perjury charges. We saw that in the Adam Montgomery case out of New Hampshire, when Kayla Montgomery, the wife of Adam Montgomery, lied to the grand jury about working in Dunkin' Donuts the morning that he has been convicted of taking the life of sweet little 5-year-old Harmony Montgomery. And Kayla Montgomery, for those perjury charges, spent at least 18 months in jail, maybe a little closer to 2 years. So it's really serious to commit perjury. Moving on. And we're skipping through a lot of this because a lot of this we've been through. So Ryan Nagel testified. We know about Ryan Nagel. He pulled up behind Karen Reed, saw her alone in the car, and then he pulled away, saw her hands at 10 and 2, didn't see a passenger anywhere around the vehicle, didn't see any damage to the vehicle. At least 6 individuals claim to have left the Albert residence in the early morning on January 29th, 2022, which was the date of death for Officer John O'Keefe. After Miss Reed had left the Fairview residence and returned home, Jennifer McCabe and Matthew McCabe testified they drove Julie Nagel and an unnamed female home at 1:30 a.m. Brian Higgins testified that he went to complete, quote, administrative work at the Canton Police Department around 1:30 a.m. And we have learned as recently as, was it yesterday already? These days are really melting together. I guess it was the day of the hearing, which was Friday, that Brian Higgins has taken a federal proffer and has changed all of his testimony. And what is a federal proffer, you say? Federal proffer is taken in exchange for leniency or immunity for federal charges. Brian Higgins is a federal employee. He is an agent, an ATF agent. He was present in the home on the night and early morning hours of January 28th and 29th, or actually just the early morning hours. I think they got there around after midnight. And he, in front of the federal grand jury, which is investigating this investigation, has taken a proffer deal. So he's changed his testimony. We went over that yesterday. Nobody saw the body on the lawn, even though they would have driven right by it. What I want to point out here is Sergeant Lank's testimony. He testified in front of the grand jury, and this is what he said. Yeah, people say Higgins flipped. Here's what he said. The recovery of evidence from the crime scene was presented to the grand jury as follows. Sergeant Michael Lank testified that the Canton Police Department recovered the following evidence from the crime scene on the morning of January 29th, 2022. 1, a clear broken drinking glass, and 2, 6 frozen blood drops, which they placed in red Solo plastic cups that were provided by a neighbor. Members of the Massachusetts State Police Special Emergency Response Team, or the CERT team, conducted a subsequent search of the Albert residence on January 29th, 2022 at approximately 6 p.m. this time, recovering 3 pieces of red and clear plastic consistent with Miss Reed's taillight. Additionally, according to Detective Sergeant Michael Lank's testimony before the grand jury, 1 week later, on February 4th of 2022, Chief Berkowitz of the Canton Police Department purportedly drove by the Albert residence on a whim and saw from his moving vehicle an additional piece of red plastic that was consistent with the taillight of Miss Reed's vehicle. Okay? This is not hyperbole by the defense. This is not speculation. This is what Sergeant Michael Lank of the Canton PD testified to in the state grand jury. The grand jury minutes, which were attached to this motion for the judge's review, were not released. But this is how he testified. No broken taillight pieces were found until after or at 6 p.m., after something like an additional 10 to 12 inches of snow fell, after the Canton Police Department had, what I would hope, thoroughly investigated the scene, starting at around 6:15 a.m., collecting blood drops in red Solo cups, borrowing a leaf blower from a neighbor and blowing away the top layers of snow, and finding a clear broken drinking glass and 6 frozen blood drops, but not finding those red pieces of taillight, which again was not found until we learned after Karen's vehicle was seized, brought to the Canton Sally Port. There's missing video from the Canton Sally Port, we know, before 6 p.m. And if you can't see it, I don't know what to tell you. They want you to believe that the Canton PD is incompetent, that they couldn't find the red pieces of taillight that the MSP CERT team found at 6 p.m. lay on top of the snow. And then just coincidentally, the Canton PD Sergeant Chief Berkowitz driving by a week later just happens to be driving by 34 Fairview and happens to find another piece of taillight there, even though they've been conflicted off the case because the homeowner, Brian Albert's brother at the time, was a Canton police officer. Are you following? So, obviously the Canton PD couldn't be in charge of an investigation happening at the brother of one of its officers' houses. So, but that's not all. Because the grand jury is allowed to ask questions of the witnesses. And it says, when an incredulous grand juror specifically inquired as to why the chief of police had responded to the Albert residence and how he discovered the evidence, Detective Lank explained, nobody called the chief. When pressed further by the juror as to why he just wandered over there, Detective Sergeant Lank recounted through hearsay he was driving down Fairview Road and he saw it. The evidence. I mean, you can't make this up. You just can't make this up. Somebody said, beautiful Betsy Bell said, oh my God, I was watching on my TV and chatting on my phone in the wrong chat. Who are you watching at the same time as me, girl? No cheating. They must think I'm the biggest Looney Tune and not a nice person. Oops. Oops. Hello, Rick Hamill. Whoa, welcome back. This case is a great litmus test to see who the sharp true crime minds are and those guilters that lack critical thinking skills. I don't know, is my brain too logical? Like, am I too logical? Because I just don't see a car accident here. And again, if there was a car accident here, where is the motor vehicle accident report? Where is it? In New York, anytime there's a motor vehicle accident involving injury, death, especially a fatality, or property damage, an MV 104 has to be filed with Albany. That's the law. Where's the police report for the motor vehicle accident? Is there one? I ask you again, I am shouting into a closet. Oh no, Scott, don't. Don't even, and don't redirect. Okay, cool. And those of you who are joining for the first time might have your jaws on the floor because you haven't heard this before. You've been listening maybe to mainstream media, if we want to call, News Nation, Court TV, and Law and Crime mainstream media, and you're not hearing about this stuff. And the people who are hearing it are just calling me a liar, like I'm making it up. Microdots, I like that. 'Twas the night before justice. I'm sure somebody could make a whole poem about it. They do not have an accident report. Is it the law in Massachusetts? Do I have any Massachusetts attorneys in the house, or Massachusetts insurance adjusters, or anybody who's ever worked claims in an insurance company? Because is it the law in Massachusetts that a police report must be filed? I mean, there were police on the scene. It's not like two people got in a fender bender and exchanged information and no police officers came to the scene to write a police report. Mother Toast, a person that claims to be a profiler, said the defense claims were ridiculous. How? This stuff as well. I think I know what you're talking about. Yes, just G.D., incredulous grand juror asking the right questions. Supermax captain. MSP accident reconstruction team must have taken the day off. They did not secure the crime scene with crime scene tape, you guys. They took Officer O'Keefe's body, put it in an ambulance, transported him to Good Samaritan Medical Center, where they had to wait to warm his body before he could be pronounced at something like 7:50 a.m. And they sectioned Karen, and there's body cam footage of Officer Good, which we found out about yesterday also. Well, not yesterday. We went over yesterday, Friday. Officer Good on his body cam footage at something like 6:30 a.m. says, I'm going to section her, which means put her on an involuntary psych hold. Yeah, good point. Kim says, how can Karen get her car fixed without a report? She doesn't have her car back. They still have her car, or they're still in possession of her car. She's still paying for her car. They still have it. It's still in evidence. Mrs. Jim Morrison, do they not have a shovel? What type of leaf blower will move heavy snow from this major blizzard? Exactly. There was only 2 inches of snow at the time that they responded to the scene. So 10 inches or 12 inches fell after that by the time they found those taillight pieces on top of the snow. So, we're all in the twilight zone. And here we go. First prong of this argument is that the Commonwealth intentionally admitted false and deceptive statements to the grand jury regarding purported admissions made by Ms. Reed at the crime scene. Again, Detective Sergeant Michael Lank, and, going back to the ties between Lank and Alberts, family friends, high school buddies. I am outraged. Donna says, yes, the police report is required and auto infraction has a citation issued. Thank you so much for that. Karen still has to make car payments. Aaron says Lally's going to be absolutely humiliated. I'm surprised he hasn't skipped town before it's too late. This whole thing just has me like, my head is spinning. Like, really? I can't believe we're still doing this. So Lank testified to the grand jury that he oversees the Canton Police Department's Detective Bureau, and he was one of the first investigating officers to arrive at the crime scene located at 34 Fairview Road. Oh, there's been somebody else on mainstream media saying that the crime scene is wherever the crime scene is. It could be at the police station. It could be at the 34 Fairview. It could be wherever the thing. I don't even know that logic, but Brian and Nicole Albert's residence just after 6 a.m. on the morning of January 29th, 2022. And there's the citation for that in the grand jury minutes. And they stay here, like in Odell, which is the leading authority on this issue, the Odell case. The Commonwealth intentionally elicited testimony from Detective Sergeant Lank regarding an incomplete and misleading statement he attributed to Ms. Reed, based not on his own personal knowledge or observations, but instead based on purported conversations he had with unidentified officers that arrived on the scene before him. And then he says, specifically, Sergeant Lank testified before the grand jury as follows. So, officers that were there prior to my arrival had attempted to speak with Karen Reed, but from what I had gathered from them, she was too hysterical and was unable to really assist in any way. The only information they were able to receive from her or retrieve from her is that she could not recall whether or not she had been there to 34 Fairview Road. However, Sergeant Lank's recitation of this rank, inadmissible, and unreliable double hearsay is incomplete, inaccurate, and intentionally deceptive. And here's why, they say. Because Ms. Reed spoke to 3 responding officers that morning before Lank even got there: Sergeant Officer Saraf, or Officer Mullaney, and Sergeant Good. Notably, Officers Saraf and Mullaney never attributed any incriminating statements or admissions to Ms. Reed, as Sergeant Lank falsely recounted to the grand jury. Instead, he regurgitated their reports and their hearsay. Thus, Sergeant Lank's testimony to the grand jury that the only information the responding officers had or were able to obtain from Ms. Reed was an admission that she couldn't remember whether she had been to 34 Fairview Road is false, incomplete, and deceptive. Because of what she said to the other 3 officers who were there before he was. Because according to the receipts that we looked at, Sergeant Good's report, Ms. Reed was hysterical and was repeatedly yelling, "Is he dead?" When Sergeant Good asked Karen how O'Keefe ended up there, that is, on the lawn, she replied, "I don't know." Sergeant Good then asked her if she drove to the Albert residence the night prior, to which she responded, "I think so." He noted hold on, I lost my spot here. He noted that Ms. Reed appeared visibly upset and unable to keep her train of thought, just like me, and told him she couldn't remember, at which point Sergeant Good stopped asking her questions. So that's what the reports say, as opposed to what Sergeant Michael Lank testified to. You know, after reading this entire motion, I know a lot of you have probably read it, but I'm wondering if any of those grand jurors have come forward and said, if I knew that that certain officers had close familial ties or close relationships with the parties or witnesses in this case, I never would have indicted her if I had the real story about the relationship between Proctor and the Alberts and the McCabe's and Lank, and the relationship between Lank and the Alberts and the McCabe's. So I wonder if any of those people are sitting at home thinking, we were We were presented with a 3-card Monty. And knowing now what I should have been told while I was sitting on the grand jury, I never would have indicted. I wonder. Jackie was thinking about that. The grand jurists. That's good, is it? Grand jurists. I guess it is. I would say grand jurists. Yeah. RB been listening and completely disgusted. Go Joe says, yes, all that needs to be highlighted and revealed. The defense goes on to say that Sergeant Lank's testimony to the grand jury distorted Miss Reed's statement to responding officers and strongly suggested incorrectly an admission of guilt, i.e. that she couldn't remember driving to 34 Fairview. In actuality, however, reports in the possession of the Commonwealth suggested that Miss Reed told law enforcement that she thought she drove O'Keefe to the Albert residence and indicated that she appeared visibly distracted and unable to keep her train of thought when the responding officer asked her additional questions, including when she made the statement to the effect of, "I don't remember." Thus, rather than ensure that the rest of Miss Reed's statement was admitted into evidence, the Commonwealth allowed Detective Sergeant Lank's false and misleading recitation of Miss Reed's statement to responding officers remain unimpeached for the purpose of unfairly implicating Miss Reed and ensuring an indictment. What say you, my friends? Thank you, Elf, for gifting a membership. That's so very kind of you. In order to be gifted a membership, you need to be participating in chat and opted into membership. So you can do that through your phone by hitting the 3 dots or something down at the bottom. I don't really know how, but I'm sure one of the mods will be happy to tell you. Next point. Detective Sergeant Lank's intentional deception regarding his long-standing relationship with the Albert family and his history of deputizing himself to investigate crimes involving the Alberts. Okay, so a lot of you, we were talking last night, about the Lopilato brothers lawsuit. And a lot of you were saying, what is that about? What do you mean that Lank was involved in a lawsuit as a defendant with the Canton Police Department and they were sued? And what is that all about? Well, we're going to tell you what it's all about right now. You're going to learn. It's not going to make you happy. And even though the judge knows all these things put together in the motion, it was still denied. So I again, Twilight Zone time. Joey just saying, thank you so much for your super chat. Thanks for all you do, Melanie. Slowly leaning into microphone. I am outraged. That's going to go down as one of the greatest trial lawyer moments in this case. And it's not even, the trial hasn't even started yet. Dennis Ballin became a YouTube member. Congratulations, Dennis, and welcome. I like that we have some men joining us. Before I started covering this case, I think my audience was 92% women and 8% men, and the men are really showing up for the Karen Reed case, and I love that. Love that. So, the argument is that Detective Sergeant Lank, an agent of the Commonwealth, utterly failed to disclose to the grand jury exculpatory information, which undermines his credibility in this case, as well as public confidence in the fairness and impartiality of this murder investigation. Indeed, publicly available federal court documents confirm that Sergeant Lank is a longtime childhood friend and drinking buddy of the percipient witnesses in this case, and that is percipient witnesses. I'll say it one more time for those of you who are just joining. A percipient witness is a witness who actually sees, hears, or has admissible personal knowledge of the evidence about which he is testifying. And Sergeant Lank has a documented history of deputizing himself to investigate crimes perpetrated by his longtime childhood friends, the Alberts, to shield them from criminal liability. For example, on August 2nd of 2007, Sergeant Michael Lank was sued in Massachusetts District Court by plaintiffs Mark Lopilato and Alfredo Lopilato, the Lopilitos, for civil rights violations pursuant to 42 USC Section 1983 in a case involving percipient witness Chris Albert and Tim Albert, who are the brothers of the homeowner, Brian Albert. And then they attach to the document the complaint in that lawsuit, which I believe is attached to this document. We're not going to have time to go over it tonight, but it's interesting. They're going to tell us what it's about. They're going to summarize it for us. Don't worry. The facts set forth in the Lopilato's amended complaint are strikingly similar to the facts in this case and allege as follows. On August 31st of 2002, Mark was sitting in a friend's car in a parking lot outside the Golden China restaurant in Canton, Massachusetts at approximately 12:45 a.m. Earlier that evening, Mark had been in a verbal dispute with several individuals, including a man named Tim Albert, brother of Brian and Chris Albert, both of whom are percipient witnesses who testified before the grand jury in connection with this case. As Mark was sitting in the parking lot, he noticed a group of several men, including Tim Albert and Chris Albert, leave the Centerfields bar in Canton and approach his vehicle. Just as a side note here, is the Centerfields bar in Canton still in existence? Let me know. That'll be on the Canton tour bus stop of all the places mentioned in this trial, if it is. Fun fact, Golden China was right across the street from D&E Pizza. Wow, Jen. Oh, thanks for coming in with the deets. Interesting. Suzanne says he might have a non-disclosure order. Yeah, a lot of times that's part of the settlements. A lot of times that is true. You have to sign a confidentiality agreement when you settle a case sometimes, also known as an NDA. That may be part of the settlement agreement in that case, and they may not be allowed to testify. But the complaint, the verified complaint in a lawsuit is a court document. It's a public record. When Mark exited his Centerfields is now the waterfall. Wow, that's wild. So the Alberts have been drinking at what is now the waterfall since at least 2007. No, this is 2002. 2002 is when this happened. Wow. Okay, people who don't understand how this could happen need to understand the generational nature of this town. Am I right? Centerfields is now the waterfall. That's crazy. Tim Albert. There's how many Albert brothers, you guys? And notice when the judge makes her decision, she only mentions Tim Albert. She doesn't say Chris Albert. And I find that curious because Chris Albert is married to Julie Albert. They're the parents of Colin Albert. We heard about them the other day when they went to Officer John O'Keefe's front porch, took pictures of themselves drinking beer while he was in Aruba on his porch to taunt him. Wow, Olivia, it's the waterfall. Hi, Olivia. That's crazy. That's crazy. I'm making that connection just now. It's a real reaction. When Mark exited his vehicle, he was attacked and beaten by Chris Albert. After the beating, Mark called his brother Alfredo to let him know what had happened. Shortly after the Alfredo arrived at the parking lot to check on his brother, Chris Albert's childhood friend, Detective Sergeant Lank, emerged from the Centerfields bar swaying and began yelling that he was a police officer. When two other Canton police officers arrived on scene, Detective Sergeant Lank instructed them to handcuff Mark's brother and place him in the police cruiser. According to Mark Lopilato, as the responding officers handcuffed Alfredo and placed him in the vehicle, Detective Sergeant Lank pushed Mark backwards, punched him with a closed fist in the face, took him to the ground and continued striking him and then bit him on the arm so hard that he broke the skin. Bit him. He bit him. Have you ever known a police officer, detective, sergeant to bite somebody? Again, am I in the Twilight Zone? Yeah, you are, and so am I. You're with me, Tracy. We're here together. Ultimately, Officer Lane, one of the responding officers, had to pull Detective Sergeant Lank off of Mark to stop the beating. After doing so, Officer Lane did not ask Lopilato for any identifying information and simply told him to leave unless he wanted to be arrested. Detective Sergeant Lank then walked over to the police car where Alfredo was being held and spit in his face. Immediately after, Officer Lane released Alfredo from his handcuffs and told him to get in his car and leave. On August 31st of 2002, Alfredo went to the Canton police station to file a complaint with Internal Affairs regarding the incident. Alfredo was sent away and told he needed to come back on September 3rd of 2002 if he wanted to make a complaint. On September 3rd of 2002, Mark Lopilato went to the Canton police station to make a complaint and describe Sergeant Lank's conduct on the night in question. Shortly thereafter, Mark and Alfredo received a summons in the mail to appear in court on September 25th of 2002 for charges related to assault and battery on a police officer, namely Detective Sergeant Lank. According to discovery produced in that case, no police reports were drafted or filed in connection with the incident until September 2nd of 2022, after Alfredo attempted to initiate a complaint against Detective Sergeant Lank. And no, in case you're wondering, you can't make this up. Lisica, I had this exact question. Did Lank bite John? Right. Maybe it was police bites and not dog bites. And there's nothing funny about this, but how isn't it ironic? Don't you think? A little too ironic. Yeah, I really do think. According to the amended complaint months later, on February 6th of 2003, Mark and Alfred Lopilato were inside a mobile gas station in Canton when Detective Sergeant Lank entered the store and asked Mark how he was doing. He told Detective Sergeant Lank that he wasn't doing well because he was being forced to appear in court, even though it was Lank who had attacked him. Seconds later, several police cruisers appeared in the parking lot. Detective Sergeant Lank placed Mark under arrest for threatening, disorderly conduct, and intimidation. Intimidation. Are you getting deja vu? Lopilato was booked and held at the police station until 3 a.m. the next morning. On October 23rd of 2003, after a 3-day jury trial, Mark and Alfredo Lopilato were found not guilty of all charges arising out of the August 31st, 2002 incident. That's a typo. We wonder how they're pushing this case to trial. And doesn't this case from 2002 give you a little more insight into what's going on there? How many people had to be involved in covering that up? Olivia says, Melanie, how is he even still employed as a police officer? That's the most shocking part. Yeah. Yeah. Just yeah. Wow. Canton likes using intimidation, huh? An eclectic mind says, welcome to the Commonwealth of Massachusetts. I live here and I can't wait to move. It is crazy. Olivia says, yes, that's what I was saying. This case is like today all over again. They even charges, right? Threatening, disorderly conduct, and intimidation. It's like the playbook. The ADA, who handled the witness intimidation charges arising out of the February 6, 2003 incident, thereafter dismissed the charges after admittedly realizing Sergeant Lank was a liar. The Lopilato's civil case against Detective Sergeant Lank ultimately settled out of court. We heard Lally in court saying that this case was dismissed by the parties. And I corrected him and I told you cases are not dismissed by parties. Cases are dismissed by a jury and cases are dismissed by a judge. If it's between the parties, it's due to a discontinuance because of a settlement or a discontinuance because the plaintiffs dropped the case. That is not what happened here. It was settled. Canton paid the plaintiffs something like, I've heard varying amounts, $200,000, something like that. Significantly, however, during the course of that litigation, Detective Sergeant Lank made several admissions in federal court documents which directly bear on his credibility in this case. 1, he admitted he consumed approximately 4 to 5 beers at Centerfields before deputizing himself to investigate a crime involving his longtime friend, Chris Albert. 2, he admitted that his friend Chris Albert approached him with his wife Julie Albert on the night in question and indicated that he had just gotten into a fight with Mark Lopilato. 3, he admitted that he had observed Chris Albert's hand to be swollen. And 4, he admitted that he's a longtime childhood friend of Chris Albert. This is somebody says, which DA was this? This is the DA from 2002. 2003, when those charges were brought against the Lopilatos, based on the lies of Sergeant Lank. Notwithstanding his close relationship with the witnesses in this case, meaning the Karen Reed case, and the fact that he was personally sued for using his position of power to cover up crimes involving the Alberts, Detective Sergeant Lank testified in this case as if he was a completely independent, neutral investigator with no relation to the Alberts, the very family he was supposed to be investigating. I can go to the chat to the second. See if there's anybody here who's never heard this information before and how you feel about it. Because this is an interactive show, and I really do like to know what you guys are thinking and how you're feeling. And whether any of the grand jurors who sat on Karen Reed's grand jury feel like they should have known about this relationship between Lank and the Alberts. And is somebody going to say, oh, but it was Chris Albert. No big whoop. It was Brian Albert's house that it happened at, this incident. So, Chris Albert, he's like the brother of Brian Albert, who also has a son who was in the house. And there's conflicting statements about whether he was at the house at all. So, anyone? Bueller? Anyone? And yeah, if in this cast a list of characters, one is more despicable than the next, like Despicable Me. Like that character that we looked at. The Druid says 4:30 a.m. in the UK, and I tune in to find that the Canton PD and MSP are still utterly corrupt. Well, there's a shock, but it gets deeper and deeper and deeper. Deline says it's scary as heck that these are the people meant to be upholding the law. Yeah. Talk about bad character, right? We're talking about bad character evidence. Like, do you think that this information about Sergeant Michael Lank should be admitted in Karen Reed's trial? I mean, certainly it's going to be used on cross to impeach him. Certainly. But can the judge say, no, you can't use it because, this was over 20 years ago? Because I think that's what she said in her decision, right? Over 20 years ago, he had a relationship with, something to do with Tim Albert. In fact, didn't mention Chris. It just gets crazy. Patty says, when they make the movie, promise me you'll be the commentator. Oh, I would love that job. I would love that job. Absolutely, says Tracy. V. Louise Arthur says, this couldn't even be a movie. It's much too nefarious. Phoebe says, they're insofar it's normal to them, the club. Sam says, comically obvious corruption. Scott says, and Scott is a local, It's hard for outsiders to grasp how tight and connected all these peeps are. All the cops, both local and state, the DA, the McAlberts, all centered in Canton, Massachusetts. They all know each other. Yes. What is the population of Canton? Can anybody answer that for me? Because I am not quite sure. I'm sure somebody can Google that. Absolutely should be used. Right. Heidi says, I'm horrified with the biting. What if it was a human bite on him? You can't make this up. Jay says, I haven't heard this. How on earth does Lank still have a job? Should he have been fired over 20 years ago? Sherry says, sadly, there's nothing grand jury members can do now, correct? Not that I'm aware of. Except maybe after this is all over, give interviews. I don't know. This is scary. And this is scary because Karen Reed could be any one of us. Angela says, this reminds me of a case in 1993 of police corruption in Boston that convicted an innocent man for shooting a cop. Netflix doc called Trial 4. Police lying for each other just like this. People don't understand how this can happen. There are people out there would be so many people involved in this conspiracy. Okay, well, here's actual real receipts of what Lank did all the way back in 2002. That's how long he's been a friend of the Alberts. That's why he's the first guy in the house to do a group interview with his childhood friends. That's why he doesn't search the house. That's why nobody checked to see if the drinking glasses are in the house of similar kind to the one that's on the lawn. As I think it was David Yannetti said, they called in a friendly Michael Lank to come and be the first on scene. Isn't Chris Albert now a selectman in Canton? He sure is. He sure is. Beautiful messy ball. She wanted the defense to present third-party culpability. She's to be a hypocrite now to keep it out. The narrator, yes. It's mind-numbing, microdots. Biggest corruption case in world history. It may be. It may very well be. At least in Massachusetts history. U.S. history. I mean, and the thing is that nobody could believe it. Nobody believed it. People thought anybody who was reading the documents and starting to think that there's no way Officer John O'Keefe was hit by a car and a car hit Officer John O'Keefe. We were crazy conspiracy theorist lunatics. And this guy is one of the major players in this case, first one on the scene. Oh, you guys, mods, if you are tired, go. We'll be fine here. I know that this has been a long day. I'm going to try and not make it too long. We've been here for an hour. Let's if you have to go, please go. And on that note, if I'm going to do gavel to gavel on this trial, if it actually goes forward, which I believe it will, if anybody would like to be a mod or would like to volunteer to be a mod and join the mod squad, this channel is growing like crazy and we need more mods. Feel free to email me. Someone will put up the email. Email me your experience, your CV, you have to be really willing to give me your personal information, like your name, address, date of birth, and that kind of stuff. It is a volunteer position, but it is very satisfying. And my mods are the best. Well, Cupcake's like, double feature, I'm here for it. Whoa. Yeah, if we're keeping Melanie up late, we could at least like. It's okay. I'm a night owl. It's totally fine with me. I feel bad for my mods who live on the East Coast who are like tired. Yep. MD and the DA comes out saying who's guilty or not in public comment. That is right. That is correct. Sam says, is this accurate about the homeowner cop? The deceased was found on his front lawn. He never came out of the house. Nope. He never came out of the house. He says that he was sleeping. But there's phone records that show that his wife's sister, who's Jennifer McCabe, called twice while she was outside. And those calls were answered and they spoke. So, a lot of butt dialing in this case too, you may notice. And back to the documents. Because, it just keeps getting crazier. The Commonwealth never elicited any testimony from Detective Sergeant Lank informing the grand jury that the Canton Police Department was conflicted off this case. Detective Sergeant Lank testified that he notified a separate investigative agency, the MSP, for some unspecified reason to respond to the crime scene to investigate the case, and that Trooper Michael Proctor returned his call. Here's what he said. When somebody of the grand jury asked a question asking what the CPAC unit is, and why they were called, Lank responded, CPAC unit is the state police unit that investigates homicides or deaths. Anything suspicious, they would respond. Thus, Detective Sergeant Lank falsely implied to the grand jury that the Canton Police Department lost jurisdiction because the state police always respond to investigate homicides, and withheld the fact that the agency he works for, the Canton Police Department, was conflicted off the case. In reality, as admitted by Norfolk County District Attorney Marcy, when the statement served him, the Canton Police Department recognized early on they had a potential conflict and asked state police to take over the Reed investigation as soon as they realized O'Keefe's body had been found at the home of Brian Albert, whose brother Kevin works for the Canton Police. Oy vey. Oy vey. That's all I could say. Detective Sergeant Lank further testified before the grand jury that he was not scheduled to work on January 29th of 2022, but he responded to Brian Albert's residence anyway to investigate the death of a Boston police officer who was found severely injured at his residence. Thus, just like in the case involving Chris Albert, off-duty Sergeant Lank deputized himself to investigate a crime in which his longtime friend was a witness. Thank you, Kelly. Canton population in 2018 was 23,600. Okay. But in essence, you're always working. Is that fair to say? That's what he said to the grand jury. In spite of Detective Sergeant Lank's clear conflict in this case, he personally took it upon himself to conduct the initial interview of the homeowners, Brian and Nicole Albert, and personally memorialize the reports regarding their statements. One of the members of the grand jury, perplexed by Brian and Nicole Albert's decision to hide inside their residence on the morning of January 29th, specifically asked, did the homeowners or occupants of the home ever appear on the scene and interact with any of the officers? Officer Mullaney responded that only Sergeant Lank and Sergeant Good entered the residence to speak with them. The juror again said, but they never came out to interact while you were there? To which Officer Mullaney replied, not that I recall, no. Another member of the grand jury at the close of Sergeant Lank's testimony asked, so how close to the house to where the body was laying, and with the fire department coming down and the lights going, no one from the house heard the noise and came to say what's going on? Quite obviously, the grand jury was disturbed and confused as to why the homeowners sequestered themselves in their residence and hid themselves from the police. Detective Sergeant Lank also testified before the grand jury that he returned to the Albert residence at 9 a.m. after being contacted by Brian Albert's sister-in-law, Jennifer McCabe, because she supposedly had more information that she wanted to share with him, and told him she forgot to tell responding officers that while she and Karen were driving around looking for the victim, that Ms. Reed had made the statement, I hope I didn't hit him, and that Karen made the statement again at the scene after they discovered the victim. That is what Detective Sergeant Lank told the grand jury. Jennifer McCabe called him at 9 a.m. and brought him back and said, I forgot to tell you some stuff, and here's what I forgot to tell you. Detective Sergeant Lank and the Canton PD were already supposed to have been conflicted off the case, making it completely inappropriate for Sergeant Lank to conduct any further interviews with his longtime family friends. And so all of these things, as such, they argue, is enough to get it thrown out. But no, 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 because there's more. Trooper Michael Proctor, the Massachusetts State Police detective called in by Detective Lank to cure the conflict and take over the investigation, is also close family friends with the Alberts. And they attach photographs, and we've been over them before, together at weddings. Trooper Proctor's mother referring to Chris, Julie, and Colin Albert as her second family. And here, as the lead investigator assigned to this case, Trooper Proctor testified extensively before the grand jury regarding his interviews with witnesses, the seizure of evidence, and observations related to the case. Yet not once in Trooper Proctor's hundreds of pages of testimony before the grand jury did Trooper Proctor ever disclose his long-standing relationship with the very same witnesses he personally interviewed in connection with this case before he took the stand. Instead, the Commonwealth and its agents intentionally misled the jury by having Trooper Buchanan read his report memorializing Trooper Proctor's interview of Chris and Julie Albert on February 10th of 2022, stating, following formal introductions, Julie Albert provided her cell phone number and Chris Albert provided his cell phone number. Now remember that. Chris and Julie Albert were interviewed on February 10th. And that's how that went. And for those people who called me a liar when I said that Trooper Proctor had possession of Officer John O'Keefe's cell phone, it's right here. He testified to that in front of the grand jury. For example, at the grand jury, Trooper Proctor testified extensively regarding ring video surveillance obtained in connection with this case. Trooper Proctor testified that he was able to personally access the ring application on O'Keefe's cell phone, which stored motion-activated video surveillance footage capturing O'Keefe's driveway on January 29th of 2022. And the only ring video that was turned over for the grand jury to watch was the one at 5:07 a.m., capturing Ms. Reed leaving O'Keefe's residence looking for O'Keefe, in which she strikes his car, thereby cracking her taillight. But again, we went through this in the other motion, and they didn't show the jury the whole video. They stopped it. It was outrageous. And that may be how the earlier ring video got deleted, Phoebe, because he personally accessed the Ring doorbell app from O'Keefe's phone after O'Keefe was dead. But they want you to believe that Karen Reed had access to that Ring camera footage and that she's the one who did it. Again, they didn't let the grand jury see that the cause of death on the death certificate is undetermined. Here's another thing we pointed out before in witness statements. The Commonwealth intentionally failed to elicit Chris Albert's inconsistent statement regarding whether he went to his brother's house at 34 Fairview Road on the night in question. During the course of the grand jury proceedings, the Commonwealth allowed Chris Albert to testify that he left the waterfall on January 29th, 2022, walked home, and never went to his brother's house located at 34 Fairview Road for the after party. His wife, Julie Albert, similarly denied going to her brother-in-law's house after the waterfall and testified that she went home to go to sleep. However, according to Sergeant Yuri Buchanan's interview of Julie and Chris Albert on February 10th of 2022, Julie and Chris Albert both indicated they were present at the Waterfall Bar and Grill the night of January 28th, 2022, and then followed to Brian Albert's home in the early morning hours of January 29th of 2022. My friends, this may be some of the most explosive and interesting cross-examination that you have ever seen in any trial that you have ever watched for the entirety of the trial. Somebody said, how far is his house from Chris walked home? How far is Meadows from Waterfall? Did they move from Meadows before January 29th of 2022? I'm not sure. But if they still lived on Meadows, somebody says it's the 30-minute walk. I don't know. Because they did move at some point, because there was some talk about a block party. Scott says, Chris and Julie lied. They were at the house party too. FBI caught their lies. Sherry says, every time I watch stuff about this trial, I get more and more outraged. I sure hope the jury sees what's actually going on here. Kojo says, all those demonstrating in the streets, highways, and byways for truth, you are most admirable, amazing, inspirational. Yeah. Because everyone's First Amendment rights are at issue here with this 200-foot buffer zone. The Commonwealth knowingly and recklessly failed to elicit the inconsistent statements made by Chris and Julie Albert during their interview with Sergeant Buchanan on February 10th in 2022, and instead allowed them to testify unimpeached that they never went to the crime scene on the night in question. In case there was any question as to what information ADA Lally did not want the grand jury to hear, during the course of the grand jury proceedings, ADA Lally explicitly instructed Sergeant Buchanan to read the entirety of his report, memorializing his February 10th conversation with Julie and Chris Albert, starting with paragraph 2. My friends, guess what was in paragraph 1? The statement that says both Julie and Chris Albert were present at the Waterfall Bar and Grill the night of January 28th, 2022, and then followed to Brian Albert's home in the early morning of January 29th, 2022. So I think I've been giving Lally a little too much slack this entire time. I kind of thought he was a lackey. Good night, Cal. Thank you so much for all your help today. I appreciate you. I love you so much. It looks like maybe Mr. Lally is sly as a fox. But it's all coming out now because, hey, typically grand jury proceedings are secret. Nobody ever sees the transcripts and stuff. But, since the feds were investigating this investigation, all this stuff came out. They also intentionally failed to impeach Julie Albert with an express admission to law enforcement that she knew O'Keefe was dead before his body was supposedly found by her sister-in-law, Jennifer McCabe. Because in her initial statement, her February 10th interview, Buchanan writes in his report, Julie Albert told law enforcement that she was asleep at 4:55 a.m. on January 29th when her phone woke her up and it was Jen's missed call, and that is how she found out about John dying. That's in the report from February 10th. Notice it was Buchanan's report, not Proctor's report, but here's what she testified to in front of the grand jury. She said, I just woke up and the first thing I do in the morning is, like we all probably do, is check our phones. And I woke up to a missed call from my sister-in-law, Jen McCabe, and I think it was about 5:50. And I immediately looked and it was weird because my phone is always on. The ringer is always on, but the text is always shut off at night. So my kids know if you need me, call my phone, don't text my phone. And I kind of looked. She called. I thought it was just whatever. I didn't think obviously anything bad. I just thought maybe she did a butt rolled over on her phone, something happened. So I got up. That day was my nephew's birthday, headed over to Brian and Nicole Albert's house, and my brother-in-law opened the door. And that's when they said that, there's been an accident of some sort. You get a phone call at that point in the morning and you don't think there's anything wrong? Yeah, exactly, Kathleen. Julie just showed up at the murder scene in the morning with donuts and a birthday gift at 6:30 a.m. And that's there. That's there for you all to see. But it gets even worse because let's talk about the bad character evidence from Aruba. And we've been over that before. And if you haven't seen it, go back and watch one of my prior streams where we talk about Aruba. And the defense says, although every single witness unequivocally testified that there was no history of violence whatsoever in Miss Reed and O'Keefe's relationship, the Commonwealth repeatedly elicited inadmissible testimony regarding an incident that occurred in Aruba 1 month prior, which had no logical relationship to the crime charged. We heard about Paul O'Keefe testifying about what he heard from other people. We went over all of that stuff. But what I want to point out to you is that, where's my highlighted portion? The Commonwealth later instructed Trooper Proctor to read another law enforcement officer's report, memorializing his February 8th, 2022 interview with Laura Sullivan about the Aruba trip to the grand jury, which, in addition to being an inadmissible prior inconsistent statement, also contains at least 4 layers of inadmissible hearsay. I'm pointing out to you here that Laura Sullivan, who's a witness to nothing other than what her sister told her about Aruba, was interviewed on February 8th of 2022, 2 days before Chris and Julie Albert were interviewed. And if that doesn't shock you, my friends, nothing will. Do you mean to tell me that law enforcement was so interested on in finding out some dirt on Karen Reed to give her a motive to intentionally murder her boyfriend, that they were interviewing witnesses who were on a trip to Aruba with them before they were interviewing witnesses like Chris and Julie Albert? Are you kidding me? That's where the focus of this investigation was. A little more than a week after Officer John O'Keefe was killed. They're interviewing people who went to Aruba with them. You should be outraged. These are the people they're focusing on. They didn't even interview Lucky Lochran, the plow driver, until 18 months after. They didn't interview other people who were in the house. Are you kidding me? I'm outraged. All that stuff about football games and all this other nonsense about kissing Marietta in the lobby. These people were interviewed before witnesses who had actual knowledge of what happened that night, and it's disgusting. He offered 5 witnesses, Lally did, to the grand jury on this Aruba trip. 4 of them were not even in Aruba. Just to say, in Marietta Sullivan's words, that Karen Reed is an a-hole. And then they called Paul O'Keefe's wife, Officer John O'Keefe's sister-in-law, to testify. And here's what they got from her. Erin O'Keefe. ADA Lally asked her to describe any arguments Miss Reed and O'Keefe might have had, even if they were relatively minor. Eventually, Erin O'Keefe responded, "My mother-in-law sometimes, he thought she spoiled the kids too much." Commonwealth further elicited testimony from Erin O'Keefe that on the afternoon of January 28th, 2022, Ms. Reed texted her to say that O'Keefe had accused her of spoiling the kids because she took his daughter to Dunkin' Donuts. ADA Lally then intentionally elicited the same cumulative testimony as hearsay from Paul O'Keefe, the brother of John O'Keefe. Answer: John didn't confide in me too much or talk about it too much. It's mostly stuff that I've heard through my wife because she had a relationship with Ms. Reed. Question: what are some of the things that you've heard through your wife, Aaron? Answer: the typical complaining about, what they would fight about when they did fight, mostly based around buying stuff for the kids, spending too much money on the kids, spoiling the kids. My brother he wanted them to have more of a humble upbringing as opposed to, having fancy, expensive clothes or stuff to that effect. Yeah, it was Duncan. It was Duncan. It was Duncan. And Karen was spoiling the kids by buying them fancy clothes. And what does that say to me? That she loved those kids. All of this is BS. And I can't even believe that this was allowed in front of the grand jury. And I want you all to see this. These are the receipts. This is all quoted from grand jury transcripts. What this shows me is that Karen loved those kids. She was spoiling those kids, and maybe they argued about it once or twice. Really, that's the best you could do here as a motive for murder? That they had an argument that morning because she bought the daughter an iced coffee before school. Oh, it gets better, though, because Michael Camerano, who's the friend that was with John O'Keefe that night at, I think, C.F. McCarthy's, they went there together. He testified that O'Keefe mentioned being annoyed with Karen because she hadn't asked him to help her fix a plumbing issue at her house and because she sometimes spoiled his kids. So, I mean, there's another motive. She called a plumber instead of letting John fix it. They had a little squabble about that and, spoiling the kids. And then Jennifer McCabe testified. Karen told her on January 28th, 2022, that she and John had gotten into a disagreement earlier because she had taken his daughter to Dunkin' Donuts to get an iced coffee before school, and John was upset about it. The cumulative effect of this prejudicial evidence cannot be understated. And they kept calling people and more people and more people and more people. And I can't even look at this anymore because it just makes me mad. But I want to know what you think. And for those of you who may just be joining, these are the documents that were unsealed to the Boston Globe just last week, but we have never been over them before. And I thought tonight, on the eve of trial, the actual eve of trial, sometimes that's used as an expression, but it really is the eve of trial, to look about all the stuff that Lally introduced to the grand jury. Margaret Hutchins. All right, comment of the night. So is Karen in the kitchen with a broken faucet? I'm confused. Yeah. Yes. Swendig. Oh, okay. I love going over the documents with Mel. See, I'm not a liar. It's right there. It's right there. It's in the grand jury testimony. What say you? Thank you, Dennis, for the 10 spot. Says, thanks for all your time on this case. Thank you. I have fallen in the rabbit hole and I can't get out. I say, call me Alice. I'm in the rabbit hole on this. And I only started covering this case on this channel, I want to say maybe in January. And I'd been looking at it behind the scenes for a long time. And I just couldn't believe it. And I was outraged. And that's why I started covering it, because I wanted you all to see what I saw in the documents. Dennis, thanks for gifting a membership as well. And Donna, thanks for being a new member. And Lauren, thanks for being a new member. And Lori, thanks for being a new member. And you guys, we have a lot of fun here. My cupcakes. Scott, thanks again for another super chat. You have to know that the initial lie was to minimize who was at the house. Initially, only 6 people. Currently, FBI has 13 peeps in the house now. Yeah, I can't wait to see that geofence data. Thanks, Elf, for gifting a membership. Nay, thank you so much for your super chat. Good day from Australia, Melanie. Love your work in this case. So glad you picked it up. I'm outraged. Yannetti is Batman. Jackson is Iron Man. And Liza is Pepper Potts. Bring on the Justice League. I like it, Nay. I like it. And good day, Australia. This is a good time for you guys, right? So it's like 6 p.m., right? On 6 p.m. on Tuesday. So you're ahead of us. So the jury selection has already happened in Australia. So tell us what happened. Spoiler. 16 hours ahead, right? Some guy with cancer. I'm so sorry about that, but thank you for the super chat. Not Dunkin' Donuts, the horror. Yep. It's all about the Dunkin' Donuts, my friends. All about the Dunkin' Donuts. But since we are here, and I cannot look at any more of those documents because my head is spinning and my brain is fried, and I want you to see just a little something about what Vinnie Politan had. And I guess it was his show last night. I don't know if you've seen it, but this may be some of the best coverage on this case that I've seen, in addition to the New York Post article that dropped today that I was quoted in. That I put it on the community page of my channel. If you have not seen that New York Post article, please go read it. Please comment and let me know what you think about it, because I think the reporter did an amazing job, because she knew nothing about this case. And it's a long article for the Post, but I thought it was fair. This is what Vinny had this woman on last night. I think she's a body language expert, about the video that Lally showed in court. That he said Karen was going to say that she saw Brian Albert and Colin Albert smash John O'Keefe's head into the taillight of her car. That's what Lally said this video was going to show. And as we know, it's not what she said at all. But let's listen to what this talking head said on Vinny's show last night on Court TV.
After John O'Keefe was found dead on the lawn of Brian Albert's home, I immediately got a letter out to the state police saying, I represent her, I will surrender her, no need to arrest her, just call me and I'll bring her in. They ignored that and they arrested her to get her into custody. I would assert ultimately to make the arguments that Mr. Lally's making today. Astonishingly to me, after the grand jury issued indictments, based on basically no new evidence, they upcharged her and once again did not contact me, despite the fact that she was completely in compliance with the terms of her release and had made every court appearance. They arrested her again.
All right, let me bring in my special guest and actually bring her back in. Joining us in Orlando, Florida, human behavior expert, jury consultant, Susan Constantine. Susan, thanks so much. First, I want to begin with the statements that she's making. And I understand she had been arrested previously, lesser charge, gets rearrested, and then starts making these statements like, you're aware, when she's told she's been charged with the murder, you're aware he's beaten up by Brian and Colin Albert. What'd you think of the tone and the nature of these statements she was making at this moment?
Challenging, and she's aloof, but that doesn't mean that she's not truthful.
Did you catch that? Challenging and aloof, but that doesn't mean she's not truthful.
So during break, what I did, Vinny, is I took all those statements and I ran it through Deceptio AI, which is a phenomenal program in detecting deception to create a nice baseline. And guess what? Drum roll, 100% truthful.
Wow.
You hear that? I don't know what AI program this is. Anybody familiar with this? 100% truthful. She ran it through an AI program.
100%, not one word was out of character. So the language that she was using, when you analyze it with scrutiny, with each word and the order in which she speaks it, take away the voice, just the words, came up 100% truthful. Now, if she believes what occurred, her tonality and her voice and her body language will all mirror that. And what we're seeing is she's very combative, she's very aloof, she can sometimes come across smug, and she's standing her ground. So would an innocent person do that? The question is, yes. She's challenging, which is she's not taking the other approach as the victim. She's coming at him like a bull. So just at the first view of this, without going through all of the other statements and then reading them and then analyzing them and then comparing them, just those questions are those that she said, those statements were 100% truthful.
Now, Susan, you reminded me of something when I was a prosecutor. There was one person who I was convinced was innocent. There was a grainy, this is, way back when, so the video was grainy, obviously, and it was of someone stealing something. And the person who was accused came into the prosecutor's office to view the video with his attorney. And they showed him, they said, because the prosecutor, I wasn't handling this case, someone else was, but I was right there watching it. And the defendant looked at the video and said, that's not me. That's not me. And I could tell that he was convinced it was not him, like he knows what he looks, and was screaming at the top of his lungs, yelling at the prosecutor, and stormed out of the office, and his lawyer was left behind. I could not believe what I had just seen, but it stuck in my mind all these years, the defiance and going after the prosecutor because you have wrongfully accused me of something. That's not me in the video. And what I just heard you describe is to a lesser degree what you're noticing, because she's not blowing up at that moment, but is what you're noticing from this body cam video.
Yeah, and we've both been in the courtroom, worked on many, many cases, so I know exactly what you're talking about. I've had another case where there was a police officer who was actually on the jury. And in fact, one of the attorney said, I don't want him on the jury. I said, no, I want him on the jury. He's saying everything right. He's totally in sync with what I'm looking for. And at the end of the trial, he looked over when he was found not guilty. He smiled at the defendant. So the point is that it's really easy to make these assumptions because somebody's angry or they may look like the bad guy or whatever, and they could be completely innocent. If there's a great Netflix movie that just came out, which was The American Nightmare. If you would have watched the very beginning of that, you would have thought for sure he was guilty.
Don't give away the ending. Don't give away the ending. I'm going to watch it now this weekend.
Okay, sorry about that.
No, that's fine. Susan, we're out of time for tonight. Thank you so much for staying into the second hour with us. Really appreciate your insight. Great to see you. Have a wonderful weekend. Susan Constantine, folks. All right, when we come back, we'll bring in our think tank, Ben Chu, Bernardo Villalona, Philip.
Okay, I can't watch those people, so I'm trying to put a poll in the chat. Trying to put a poll in the chat, so I have to do that on YouTube. Give me a second. I want to know if you guys want me to cover this jury selection live in the morning tomorrow, or if you want me to recap it and watch it again with you in the afternoon or evening. I do not think it's going to be very long because it's going to start at 9:30, and all that they are going to do is give a statement of the case, and she's going to give initial jury instructions. I do not think it's going to be very long. So I'm starting the poll right now. Should I cover live tomorrow or recap in the afternoon or evening? I prefer to recap it for you because the live, sometimes the feed is sucky and then it makes me upset. And I also, I like to interrupt, and that I like to stop and talk about it. So if it's going to, make people mad that I'm going to stop and talk, it may be better to do it on a delay, but I'm here for you guys. So let me know. It's not going to be an all day thing tomorrow. It's just not going to be all day. Oh, thanks, Wrestler's mom, for telling me that I'm your favorite. I love that. Thank you. Just, answer the poll. I put the poll up. It should be up, right? So you can see it, so that I can just say, see what is best for everyone. And then, look, I'm here for you. I aim to please. So, I just think, and I know some of you are going to watch it 5 times anyway, so we might as well do it whatever you guys want to do. Hey, Broken Baker just woke up at 6 a.m. and ready to go. I know that you're covering this case. I don't know a lot, but you're in Denmark, I think, right? Somewhere in Denmark or the Netherlands. I'm not sure, but welcome. And I've seen a couple of your shows. You're doing a great job. It's a lot of information, as you know, and you seem to have a firm grasp on it. So welcome over. Tell me. Oh, Tina, thanks for being a member for 6 months. I love being with my family here. Evening, please. I know you guys are, oh, Rachel, good. You're in California. These East Coast travel. All right. So then maybe it is better if I do it a little bit later. And then if I do it at a reasonable time, my UK viewers can watch it also at a decent hour. Aiden is going to be on News Nation tomorrow at 10 p.m. Oh, is that the debate that somebody had him on for? It's on all cable. Okay, so that's tomorrow at 10 p.m. Baker is awesome. Such a great guy. I'm watching here first. I mean, some people are at work and they can't watch during the morning at 9:30. Turtle Boy Live is postponed tomorrow. Okay. The live is never good from that courtroom. Recap sounds better, especially because some of us need your knowledge and explanations. I know I do. And I like to watch it live myself and then come to you with my thoughts after. Sometimes, you know, I have senior moments or absoluteheimers or, okay, live 25%, afternoon 33%, evening 42%. All right, the evening wins. Evening wins tomorrow, you guys. So I will schedule it. Make sure you have all notifications set so that you will know what time it's going to be. Make sure that you are subscribed. It is free. Make sure that you like this video to push out the algorithm. If you have not watched my stream from earlier today about the Oklahoma missing moms, please go watch that. It's heartbreaking. And it's already been shadow banned. So all the more people that watch it and share it, the better. To my moderators, I love you all so much. You work so hard and you keep it classy. And that's why people love coming here, because it's a safe place to watch this coverage. I will link the New York Post article below this video as well. And I also just want to say thank you for being here to watch this with me for all of these months and for being patient with me while I learned about this case, because I didn't know as much as so many of you knew from jump, but I think I got a pretty good handle on it now. But you were also patient and kind with me and really welcomed me into your community. And I am so thankful for all of you. So as I always say, my friends, I'm going to say it again, be cool, be kind, be classy. It is not hard. Really, it is not hard. Let playoff hockey season begin. I'm going to see all of you again tomorrow evening. Make sure you have that bell set and notification set on your phone so you will know what time, because you're not going to want to miss it. Oh, no, I'm still rooting for the Rangers, Joey. Come on, just saying. Good night.